For the respondents, my lord, Mr. Ogoso, for the first respondent. He may also go on record as holding brief for Mr. Victor, who appeared with him for the first respondent. Mr. Nyamodi, for the second respondent. Mr. Ogoso holds brief for Mr. Mwendwa for the third respondent. My ladies, my lord, Mr. Ogoso also holds brief for Mr. Angaya for the fourth and fifth respondents. My ladies, my lord, I am present for the sixth respondent, Nyambi for the sixth respondent. For the interested parties, Mr. Ochieng is present for the fourth. Ochiel, sorry, Mr. Ochiel. Mr. Ochiel for the second interested party. Mr. Ochieng for the fourth interested party. Mr. Malonza holding brief for Mr. Wambua Kilonzo for the fifth interested party. Mr. Malonza holding brief for Mr. Wambua Kilonzo for the fifth interested party. And that is the appearance of this.
Thank you again. So, as I had indicated earlier, we will start with the delivery of our summary of findings in the consolidated petitions 56, 58, and 59, and then proceed with the summary in petition 163 of 2019. David, there's an envelope with the files. Where is it? So we will read the judgment of 56, 58, and 59. Parts of it, all of us. And for petition 163, Justice Mombi Gongi will deliver the judgment. So this is our summary of findings and orders in petition 56, 58, and 59 of 2019. On 20th November 2018, the National Assembly enacted Statute Law Miscellaneous Amendment Act number 18 of 2018. The President of the Republic of Kenya gave his assent to the said act on 31st December 2018, and it commenced operation on 18th January 2019. The effect of the act was to amend several provisions of a number of existing statutes, among them the Registration of Persons Act, which we will hereinafter refer to as the Act. Section 3 of the Act on interpretation was amended to include the following new definitions of biometric and global positioning system coordinates. Section 5 was also amended to include biometric data and global positioning coordinates as information required in the registration of persons. Lastly, the amendments to the Act introduced a new Section 9A that establishes a National Integrated Information Management System, hereinafter referred to as NIMS, that is intended to be a single source of personal information of all Kenyans as well as foreigners resident in Kenya. The Nubian Rights Forum, which is the first petitioner, the Kenya Human Rights Commission, which is the second petitioner, and the Kenya National Commission on Human Rights, which is the third petitioner, are aggrieved with the amendments made to the Act, which they claim were passed in violation of the Constitution and in bad faith and pose serious and immediate threats to fundamental rights and freedoms protected under the Bill of Rights. They therefore respectively filed petitions in this court, namely High Court Petition number 56 of 2019, High Court Petition number 58 of 2019, and High Court Petition number 59 of 2019, which petitions were subsequently consolidated for hearing by this bench. The position taken by the petitioners was supported by Muslims for Human Rights, Haki Center, Law Society of Kenya, and Inform Action, which were joined to the proceedings as the third, fourth, fifth, and sixth interested parties, respectively. The respondents in the consolidated petitions are the Honorable Attorney General, who is the first respondent, the Cabinet Secretary, Ministry of Interior and Coordination of National Government, who is the second respondent, the Permanent Secretary, Ministry of Interior and Coordination of National Government, who is the third respondent, the Director of National Registration, who is the fourth respondent, the Cabinet Secretary for Information, Communication and Technology, who is the fifth respondent, the Speaker of the National Assembly, who is the sixth respondent, and the Kenya Law Reform Commission, which was the seventh respondent. The Child Welfare Society of Kenya, Ajibika Society, Bunge la Mwananchi, International Policy Group, and Terror Victims Support Initiative, being the first, second, seventh, and eighth and ninth interested parties, joined the respondents in opposing the petitions. The petitions proceeded to hearing by way of affidavit evidence, oral testimony, including by expert witnesses, and written submissions which were highlighted by the parties. The particular areas underscored by the petitioners and interested parties supporting the petitioners were the lack of information and public participation in NIMS, its threat to the right to privacy and insufficient data protection provisions, the use of an omnibus bill to enact the impugned amendments, the lack of Senate's participation, the perpetuation of marginalization and exclusion of the Nubian community and other vulnerable groups who face challenges in getting registration as Kenyans, and the lack of limitations on the powers to be exercised by the public officers in charge of NIMS. The said parties, in addition, contended that the impugned amendments seek to limit the enjoyment of fundamental rights and freedoms, but do not meet the threshold for limitation of rights and freedoms set out in Article 24 of the Constitution. They contended in particular that the new data sought to be collected under NIMS has no rational connection with the stated objectives of the Act, nor are they reasonable and justifiable in an open and democratic society. The respondents and interested parties opposing the petitions refuted these claims. Their responses will be summarized later on in this judgment. After considering the pleadings of the parties as well as their respective submissions and authorities, we identified 5 issues for determination. The first issue was whether the legislative process leading up to the enactment of the Statute Law Miscellaneous Amendment Act number 18 of 2018 was constitutional. In this regard, 3 sub-issues arose. The first was whether the Statute Law Miscellaneous Amendment Act number 18 of 2018 was subjected to public participation in accordance with Article 2 and Article 118(1) of the Constitution. Secondly, whether enactment of the impugned amendments by way of a Statute Law Miscellaneous Amendments Bill was procedural and or appropriate in the circumstances. And the third sub-issue was whether the Statute Law Miscellaneous Amendments Bill 2018 was a bill concerning counties and should therefore have been subjected to approval by the Senate. The second issue arising was whether the amendments to the Registration of Persons Act through the Statute Law Miscellaneous Amendment Act number 18 of 2018 violate and or threaten violation of the right to privacy contrary to Article 31 of the Constitution. In this regard, again, a number of sub-issues arose, the first being whether the personal information collected pursuant to the amendments to the Registration of Persons Act is intrusive, excessive, and disproportionate to the stated objectives of NIMS. Second, whether the rights of children to privacy are violated or threatened with violation by the impugned amendments. Thirdly, whether there are sufficient legal safeguards and data protection frameworks for the personal information that is collected in NIMS. And lastly, whether the impugned amendments to the Registration of Persons Act are an unreasonable and unjustifiable limitation to the right to privacy. The last substantive issue that arose for determination was whether the amendments to the Registration of Persons Act through the Statute Law Miscellaneous Amendment Act number 18 of 2018 violate or threaten violation of the rights to equality and freedom from discrimination contrary to Article 27 of the Constitution in respect of members of the Nubian community and other marginalized communities. I will now hand over to my brother Justice Korir to read our findings on the issue of whether the legislative process was constitutional.
We have considered the issue as to whether the bill was subjected to public participation, and among the things we are saying is this: all the parties agree that public participation is a key element in the achievement of democratic governance and is a constitutional imperative. All the parties also agree that the DART respondent invited memoranda from the public through adverts in the Standard and Daily Nation newspapers of 7th of May 2018. According to the respondents and the interested parties opposing the petition, the advertisement fulfilled the constitutional requirement for public participation. The petitioners and the interested parties who support the petition think otherwise. The issue for determination in this case therefore revolves around the sufficiency or otherwise of the public participation conducted in respect of the impugned amendments. We have cited quite a number of authorities, including Standing Order number 127 of the National Assembly Standing Orders, and we find that is Standing Order number 127. We find that the said provision does indeed incorporate the principles of public participation, and a close reading of the provision readily discloses that Parliament has the discretion on the method to be used in collecting views from the public, stakeholders, and experts. This observation is in line with the case law on public participation. The petitioners and the interested parties who support them have decried the lack of information in regard to the impugned amendments and NIMS itself. They also raise the issue of the sufficiency of time given to the public to submit their views. The request for representations from the public was published in the newspapers on 7th of May 2018, and the representations was to be submitted before the close of business on 14th of May 2018. The respondents and the interested parties, aligned to their cause, insist that the pre-enactment information on the impugned amendments and the post-enactment education on NIMS was sufficient in the circumstances of this case. We note that neither of the parties addressed us on which party bears the responsibility of informing the public on the bills for purposes of public participation in the legislative process. This is in light of the fact that the legislative process begins from policy formulation stage, and the sponsor of a legislation, was the background information, is a different entity from Parliament. And placing the onus on Parliament alone in this respect may be impractical inexplicable and unreasonable. In addition, there are opportunities to engage citizens at various stages of the legislative process, and this can be coordinated by various actors who are responsible for the process at any given stage, including during the content development of the bill. Therefore, there are roles to be played by the executive, civil society, and parliament as actors in the various stages of the development of a bill. Be that as it may, we note that the 6 respondents annexed a copy of the Miscellaneous Amendment Bill of 2018, together with a memorandum of objects and reasons to its replying affidavit, sworn on 28 February 2019 by Michael Shalai. The said memorandum of objects and reasons explained that the bill proposed to amend the Registration of Persons Act to establish the National Integrated Identity Management System and provide for the capture of biometric data and geographical data in the registration of persons in Kenya. The said bill was published in the Kenya Gazette Supplement number 35, into brackets National Assembly Bills number 12 on 10th of April 2018. In terms of the legislative process, the bill and memorandum of reasons and objects was therefore in the public domain from 10th of April 2018. The 6 respondents also annexed a copy of the advertisement in the Daily Nation of 7th of May 2018. The said advertisement informed on 3 events. Number 1, on the publication of the bill on 10th of April 2018. Number 2, that the amendments in the bill to the various acts would be committed to various departmental committees of the National Assembly that were listed in the advertisement. And lastly, it also invited members of the public to submit and make representations they may have had on the bill. In this respect, the amendments to the Registration of Persons Act were shown to be committed to the Administration and National Security Committee. The minutes of the sittings of the said committee on 14th, 19th, and 20th June 2019, when the amendments were discussed, were also annexed, as was a copy of a memorandum sent by the third petitioner on, dated 25th May 2018 on the said amendments. The petitioners, on the other hand, rely on the advertisement published on 7th May 2018 to show that there was insufficient time for public participation and the contents of the bill, which was amending 68 Acts of Parliament. Our view is that time was available for public participation. Our view is that the fact that time was available for public participation must be considered in light of all the processes of the legislative process. In the present petition, the evidence before us suggests that the public was aware of the bill from 10th April 2018 when it was published and could have participated from that date. The purpose of application of the bill in this regard is to notify the public and invite representations through the elected members or direct submission of memoranda and petitions. It is therefore not entirely correct to state that the members of the public only had the 7 days indicated in the advertisement of 7th May 2018 to present their views on the bill. Even after expiry of the 7 days, the doors were not closed for members of the public to participate, as there was still opportunity to participate during the committee hearings as shown in Standing Order number 127. The evidence from the respondents demonstrates that this opportunity was availed and that indeed there was participation by the third petitioner even after the expiry of the time stated in the advertisement. It is therefore our finding that sufficient time was availed for public participation. There is sufficient authority for the proposition that the entire process has to be interrogated in order to determine whether the requirement for public participation was fulfilled in respect of a given law. In the 2013 Law Society case against the Attorney General, the court stated that, and we quote, In order to determine whether there has been public participation, the court is required to interrogate the entire process leading to the enactment of the legislation. That is from the formulation of the legislation to the process of enactment of the statute, head of courts. We also recognize that there were efforts made by the National Assembly in facilitating public participation when using the omnibus bill mechanism in the Miscellaneous Amendment Bill of 2018. Unlike in the case of Law Society against the AG 2013, where the object of the bill was clearly indicated as intended to effect minor amendments, in the instant case there was clear indication that the legislature intended to carry amendments on the targeted acts without the use of the term minor. It is also clear that from the advertisement of 7th May 2018, that each act targeted for amendment was linked to the relevant committee. Therefore, in effect, only a part of the amendments, and not all of them, were subject to stakeholder engagement in the committees. That is to say, particular amendments were referred to particular committees. Coupled with the fact that there was sufficient time available to the public to give their views on the amendments, we find that there was sufficient public participation in the circumstances of this case. The next issue is the use of the omnibus bill to effect the impugned amendments. There is no doubt that the use of omnibus bills to effect substantive amendments has its shortcomings. Such a process generally limits the right of the people to participate in the passing of laws. When Parliament proposes to make several amendments to assorted acts of Parliament relating to different activities, chances are that the proposals will not receive the kind of attention they should if they had been enacted through standalone bills. The risk of excluding the public from participating in the legislative process is even more if a short period for submitting views is provided. This risk was appreciated in the 2016 Law Society versus Attorney General case. It is therefore apparent that the criticism of the omnibus bill method is that it denies the public, including parliamentarians, the opportunity to critically consider the proposed amendments and provide useful input. The limiting nature of the omnibus procedure has resulted in the courts discouraging the use of omnibus bills to effect substantive amendments to legislation. Indeed, in the 2016 Law Society case, the court did not state that the legislature should not use omnibus bill to carry out substantive amendments of acts of Parliament. What the court said is that omnibus amendments in the form of statute law miscellaneous legislation ought to be confined only to minor, non-controversial, and generally housekeeping amendments. The key word here being ought. In the 2019 Law Society case, the Court of Appeal seems to have taken issue with the fact that substantive amendments were effected to a statute law miscellaneous amendment bill whose long title indicated that it was an act of Parliament to make minor amendments to a statute law. We are therefore not persuaded that the Court of Appeal addressed the use of omnibus bills in the legislative process and concluded that the procedure could not be used to make substantive amendments to acts of Parliament. From our analysis of the authorities above, we take the view that whenever the issue of the use of an omnibus bill arises, the question to be posed is whether the procedure, as in the circumstances of the particular case, limited the right of the public to participate in the legislative process business. In answering this question, the court will take into account the nature and extent of the amendments. An amendment that is controversial, involves the spending of public funds, is likely to draw more attention from the courts. The court will be interested to establish whether the use of the omnibus procedure limited the right of public participation. However, if there is evidence placed before the court by the legislature to demonstrate that the principle of public participation was complied with in the adoption of the amendments, then the court should not be quick to hold such an amendment invalid simply because an omnibus bill was used to make the amendments. It is not in the place of the courts to dictate the procedures to be used by the two houses of parliament in executing their legislative mandate. The business of the court is to confirm that the legislative bodies have complied with the constitution and the law in delivering on their mandates. This then brings us to the question whether the use of an omnibus bill, the amendment of the impugned amendments, in the enactment of the impugned amendments negatively impacted on the right of the public to participate, thereby necessitating a declaration of invalidity by this court. In this respect, we have already found that there was evidence of sufficient public participation, and the procedure employed by the 6 respondents in the stakeholder engagement of the omnibus bill during the committee stage by various committees did facilitate public participation. The third issue is whether the bill concerned counties and therefore required the involvement of the Senate. The final issue relating to the procedural infirmities of the impugned amendments raised by the petitioners concerns the question whether the amendments were on matters concerning counties and therefore required the involvement of the Senate. The petitioner's position was that the impugned bill was a bill concerning counties and should have been approved by the Senate. The respondents strongly opposed the position taken by the petitioners and the interested parties who support them on the role of the Senate with respect to the impugned amendments. The first respondent submits that Article 109(1) of the Constitution mandates Parliament to legislate through bills that are eventually assented to by the President. He asserts that Article 109(3) of the Constitution provides that a bill not concerning county governments is considered only in the National Assembly, and Article 109(1) defines a bill concerning county governments. We have considered the respective submissions of the parties on the question whether the Senate had a role in the enactment of the challenged law. We note that the parties are agreed that the amendments were originated and passed by the National Assembly without reference to the Senate. The only question, therefore, is whether the amendments concerned county governments and could only pass with the approval of the Senate. The Supreme Court extensively dealt with this issue in its advisory opinion number 2 of 2013, which has been cited extensively by the parties before us. Although the question of whether the procedure of determining if a bill is concerned county government is not one of the issues before this court, for purposes of determining the issue before us, we find it necessary to highlight what the Supreme Court stated. We have quoted the Supreme Court at length and how it explained the role of the Senate in passage of bills. We, however, do not think that the jurisdiction of the Senate extends to each and every legislation passed by the National Assembly. To so hold would render Article 110 of the Constitution redundant. It is difficult to think of any legislation that does not touch on counties. The 4th schedule of the Constitution does indeed give a wide array of functions to the counties. Those functions, in our view, do not include a national population register. It is therefore our finding and holding that the impugned amendments did not require the involvement of the Senate in their enactment. That is not to say that the bill should not have been subjected to the procedure identified by the Supreme Court in its advisory opinion. In closing on this issue, we observe that while the petitioners have argued that the bill was not subjected to the process pronounced by the Senate in advisory opinion number 2 of 2013, the issue was not in their pleadings. As expected, therefore, the respondents did not reply to it. It would therefore be unfair to make a determination on it in light of the fact that the respondents were entitled to a right to a hearing. It is our finding, therefore, and we so hold, that in light of the above analysis, the impugned amendments do not concern counties. As such, we find no merit in the petitioner's case that the impugned amendments fail the constitutional test for non-involvement of the Senate in the process of their enactment. Back to the presiding judge.
Okay, I will proceed to read our findings with regard to the issue whether there was a violation or threatened violation of the right to privacy. All the petitioners urged on the risks and threats of the impugned amendments and of NIMS in particular to the right to privacy and of the insufficiency of the legal protection of the personal information collected through NIMS. The respondents countered these averments by inter alia explaining that the design of NIMS will ensure adequate security of data collected and that there are existing laws for data protection. The arguments made by the parties in this regard have been collapsed to the 4 sub-issues that we identified earlier. I'll start with the first sub-issue of whether there was whether the personal information collected is excessive, intrusive, and disproportionate. There were 2 limbs of arguments raised as regards this issue. The first limb was that the provisions for collection of biometric data by the impugned amendments was intrusive and unnecessary. Closely related to the first limb is the second limb, that the data collected pursuant to the impugned amendments is not supported by the stated purposes of NIMS and is purpose-free. In addressing these 2 limbs, this court was mindful of the provisions of Article 31 on the right to privacy, which we reproduced in the judgment. The article guarantees a general right to privacy and, in addition, also guards against specific infringements of privacy, including unnecessary revelation of information relating to family or private affairs, which is the bone of contention in the consolidated petitions herein. The court considered a number of judgments, both from courts outside Kenya and courts in Kenya, which have considered the nature and scope of the right to privacy. These are detailed out in our judgment. I shall not read them out. Specifically on the issue that was before us, which was the right to information or privacy, we noted that this includes the rights of control that a person has over personal information. Such personal information will in the first place concern information which closely relates to the person and is regarded as intimate, and which a person would want to keep for her or himself at least to restrict the collection, use, and circulation thereof. Examples include information about one's health. But other information about a person may also be considered private and hence protected under the right to information privacy, even if this information relates to his or her presence or actions in a public place or a place accessible for the public. Such information over which individuals have an interest to keep private, in our view, also include information and data about their unique human characteristics, which allows them to be recognized or identified by others, as it is information about one's body and about one's presence, image, and identity in both private and public places. In the present petition, the petitioners have alleged that the amendments to the Registration of Persons Act violates the right to privacy, as it seeks to introduce the collection of biometric data, which is sensitive personal data and is intrusive. Particular mention was in this regard made of the collection of DNA, which the petitioners claim can not only be used to reveal and profile a person's genetic health and other physical characteristics, but also that of their relatives. Also challenged in particular was the requirement to provide GPS coordinates, which can be used to track and conduct mass surveillance on people in Kenya, according to the petitioners. The respondents did not dispute that biometric data in digital form will be collected in NIMS, and argued that such biometric data is in any event already being collected in existing identification and registration databases, and was allowed by Section 5(1)(j) of the Act, which allows the principal registrar to keep any other particulars about the identity of a person. The respondents, however, specifically denied that DNA and GPS data will be or was collected in NIMS. In normal parlance, biometric data is any physical, biological, physiological, or behavioral data derived from human subjects which has the potential to identify an individual. Biometric data identifies an individual in this regard through one or more unique factors specific to the physical identity of a person. It is in this regard not in dispute that Section 3 of the Registration of Persons Act was amended to include a definition of biometric along those lines. It also introduced a definition of GPS coordinates, which it defined as unique identifier of precise geographical location on the earth, expressed in alphanumeric character, being a combination of latitude and longitude. In addition, Section 5(1)(g) of the Act was also amended to include GPS coordinates as part of the information to be provided on place of residence, and a new paragraph 5(1)(ha) inserted that provided for biometric data to be kept in the register of all persons in Kenya. We start our analysis by addressing the legitimacy of the privacy concerns raised by the petitioners about biometric data. The first observation we make in this regard is that biometric data, by its very nature, provides information about a given person and is therefore in this regard personal information that is subject to the protection of privacy in Article 31. We also looked at the definition of personal data that is in the Data Protection Act number 24 of 2019, which includes biometric data and also other similar definitions in other comparable legislations. We also looked at the definition of who is an identifiable natural person who is the subject of biometric data, and in this regard, again noted in the Data Protection Act of 24 of 2019, among other legislation, that data subjects are identifiable if they can be directly or indirectly identified, especially by reference to an identifier such as a name, an identification number, location data, or any other special characteristic. Therefore, the court noted that the data collected by NIMS, as evidenced by the NIMS data capture form, clearly falls within the above definition of personal data. The qualification of biometric data as personal has important consequences in relation to the protection and processing of such data, and as such invites a risk of violation of the right to privacy in the event of inadequate protection measures. The petitioner also argued that the amendments introducing biometric data allow collection of sensitive data about persons. The court looked at the history of the concept of sensitive data and also noted that the Data Protection Act of 29 now defines sensitive personal data as data revealing the natural person's race, health status, ethnic social origin, conscience, belief, genetic data, biometric data, property details including names of the person's children, parents, spouse or spouses, sex or sexual orientation of the data subject. We note that such data is considered sensitive data because of the more serious impact of its loss or unauthorized disclosure, particularly in terms of social, reputational, or legal risk. It is thus evident that biometric data, and in particular DNA, must be protected against unauthorized access, and access to such data should also be limited through sufficient data security practices designed to prevent unauthorized disclosure and data breaches. The last allegation by the petitioners was that biometric data and personal information being collected is intrusive. Intrusion is defined in the Black's Law Dictionary as a person entering without permission. Therefore, personal data is intrusive when it is collected without a person's knowledge or consent. The respondents testified in this regard that the data collected by NIMS was with the consent of the subjects, while the petitioners have contended that the data collection was mandatory and as such there was no informed consent. The response brought evidence of the data capture form used during the collection of the biometric data, which had a caption on the indicating consent of the data subject, and also testified that they had removed the statement in the said form that registration would be mandatory in compliance with this court's orders. The petitioners did not bring any evidence of any person who was forced to give consent or did not understand the nature of the consent being given. In addition, this court, in its ruling delivered on 1st April 2019, had directed that the collection of the data would not be mandatory. We, however, observe that at the time of the said data collection, there was no legal requirement for consent to be given by a data subject to the collection of biometric data. The Data Protection Act 24 of 2019, which has since been enacted, now specifically provides for the rights of the data subject, including the right to object to the processing of his or her personal data in Section 26 thereof. The Act also further provides in Section 31 that the data subject must consent to the processing of his or her personal data. We are therefore constrained to find that the data collection exercise undertaken pursuant to the impugned amendments was done with the consent of the data subjects. As to whether the categories of personal data that was collected pursuant to the impugned amendments is in their nature intrusive, this court is guided by the observations in the working document on biometrics by the Article 29 Data Protection Working Party, which was an independent European Union advisory body on data protection and privacy established under the then EU Directive 95/46 of EC, and where it stated that from a data protection point of view, the fact that some biometric systems are based on information like fingerprints or DNA samples that may be collected without the data subject being aware of it, since he or he may unknowingly leave traces, means that such data is intrusive. In addition, the working group noted that the problematic aspect of this data is that the data collection and processing may be performed without the knowledge of the data subject, and on the other hand, they lend themselves to blanket utilization on account of what they termed their low-level intrusiveness. And it concluded that it is therefore necessary to lay down specific safeguards with respect to these types of biometric data. On the concerns raised on the privacy and surveillance risks posed by the requirement to give information on GPS coordinates, this court takes judicial notice of the fact that GPS technology is satellite-based and is now widely used in different aspects, including in cars and in mobile phones, to help in determining directions and locations. The potential use of such technology may include information from the providers of telecommunication service that permit real-time tracking of the direction, speed, and locations of monitors. The privacy implications and risks arising from the use of GPS monitors is that the said devices can be used to track and monitor people without their knowledge. And in this case, particular respect, the court referred to a decision by the Supreme Court of the USA in United States versus Antoine Jones, where the court did find that the attachment of a GPS tracking device to an individual's vehicle without a warrant was a breach of their right to privacy. The facts and the findings are detailed in the judgment. The upshot of our findings is that biometric data and GPS coordinates required by the impugned amendments are personal, sensitive, and intrusive data that requires protection. This court prohibited the analysis and use of the personal data collected during NIMS for this reason, and even though there was no evidence brought by the petitioners of any violation of rights to privacy in this respect, this court finds that the impugned amendments impose an obligation on the relevant respondents to put in place measures to protect the personal data. To this extent, it is our finding that the question as to whether there is a threat or of a violation to the right to privacy in the provision for collection of biometric data and GPS coordinates will await an examination of the existing legal framework on the protection of this data. It is also notable that in Article 31C of the Constitution, a violation of the right to informational privacy occurs when personal information is unnecessarily required or revealed. Therefore, the outstanding question before us is whether the requirement of and collection of biometric data was necessary or not. The petitioners in this regard urged that the said biometric data was not necessary for reasons that its purpose was not stated and it was purpose-free. Closely related to this argument was the averments by the petitioners that there is unnecessary data that was collected under NIMS that was not necessary for identification, such as information on agricultural activities and land holding. The petitioners also challenged the utility of the biometric data in identification, and their expert witnesses testified to the challenges some of the sections of the population may face in enrolling or authenticating certain biometric features, such as worn fingerprints, and the possibilities of reaching false conclusions while relying on biometric data, as it relies on probabilities. Thus, that there will be no deduplication of the data. The justification put forward by the respondents for the collection of biometric data was that the right to privacy is not an absolute right, that biometric data is necessary as the most deterministic method of identification, and that reliable data is necessary for the state to provide services and security to its citizenry. The respondents also urged that the biometric data being collected is necessary for the purpose of creating a digitized national population register as a single source of personal information on all Kenyan citizens and residents. Their expert witnesses gave detailed evidence on the NIMS design as a multimodal system that will ensure that the biometric data is deterministic. We have considered and appreciate the detailed